The Hermès versus MetaBirkin trial is underway in Manhattan. Luxury brand Hermès filed a suit against artist Mason Rothschild after the artist released the MetaBirkin's NFT collection, which depicted the famous handbags without Hermès's permission. Now, the trademark infringement trial is set to determine if the artist improperly used the trademark and potentially confused customers into believing Hermès was behind the project. Now, the latest in this trial started yesterday. The judge has ruled that the artist is not allowed to bring testimony from an art critic who studied Andy Warhol. Now, why this is interesting is because Andy Warhol depicted those Campbell Soup's cans, right, without any kind of permission from Campbell Soup, and the artist is trying to draw a parallel here between his art and Andy Warhol's art. So, Wendy, that big sigh meant I'm just going to pass this off to you now. What do you think?
Yeah, so I get the whole argument behind it, but we're talking about Andy Warhol, which was from a completely different time period. They didn't have all the laws and regulations kind of protecting artists, protecting brands, protecting creators back then. So I understand the argument, but I don't know if it's going to fly in court. It's also going to depend what jurisdiction this is in. But again, NFTs are simply created to kind of solve that problem with all the different licensings and rights and all of that stuff. So it's going to be interesting to see what direction the court takes here. But at the same time, I do think that people should maybe not try to steal other people's stuff and profit off of it. And if you are going to profit off of it or plan to use any type of similarities, please consult an attorney or a legal expert and don't just do stuff. I don't know if they did prior to that, but it's what it kind of sounds like.
It feels like this was maybe an ask for forgiveness over permission type deal. That is pure speculation. But the artist says that he believes his artwork is protected under the First Amendment, which allows for freedom of expression and freedom to create art. Zach, do you think he has an argument here?
I don't know. I'm no judge. I don't know intellectual property. I will say, I think the subtext here is that, big fashion is kind of into Web3, right? We've seen all these integrations from big fashion houses who are doing NFTs, who have some degree of sort of metaverse curiosity. And I would imagine here that Hermès, though it hasn't started off in the space just yet, may have aspirations to that down the road. And they don't want their IP to be confused with some random NFT artists out there in the world. So I will say, I think like digital fashion and all that stuff that saw a little bit of momentum at the end of last bull run, I think there is a case to be made that the industry sees this as valuable. And when I say industry here, I mean the high-end fashion industry. It's something that they're using to engage their consumer base. And so they want to protect their entrance into that space should it occur. So I think for me, like that's sort of the big picture here, or maybe the subtext. Maybe this is just a spat over intellectual property, and maybe Hermès is especially litigious when others aren't. I really don't know the backstory here as it relates to their efforts on this, but I do think that's the bigger context in which these stories are playing out. High fashion wants in on the NFT game, has had some early success with NFTs from Dolce & Gabbana to others, and I think all the big brands are lining up to figure out what it is that they're going to do in the space. And I think this court proceeding is likely trying to clear the way for a bit more clarity should Hermès jump in. But hey, that's speculation on my part. Christy, what are you thinking?
Well, I just want to kind of go back to Wendy's point about a different time and place with the Warhol situation. The thing with Warhol versus Campbell Soup is Campbell Soup actually did consider legal action. They considered a cease and desist order. But the thing is that the art director at Campbell Soup and the CEO, or let's see, the son of the inventor of condensed soup, was himself an art fan. And he actually kind of took a step back and went, you know what, maybe this is art. Sure, they're using our soup cans, but this is art and we're going to be okay with it. And at the time, those Andy Warhol prints were basically going for $100, and I think it says something like only 7 of them sold or something. So 5 of them sold. So there wasn't this like massive influx of money that Campbell's was, suddenly worried that they were missing out on. And they actually came to the decision themselves that, yeah, this is art and we're not going to mess around with it. Hermès, on the other side, they are exercising their right to, I guess, say, no, this is not art, this is our intellectual property. But I think that there is precedent in history for this kind of thing to be done. I mean, when you think about it, a lot of the AI that's out there is also, and which I know is also up for grabs in terms of whether or not that intellectual property should be protected. But all that stuff is out there getting used and abused, and I think this is just one more instance of that. And I think that we're just on a new frontier when it comes to digital art and the origins thereof.